welcome back to the channel. Hope you're all keeping well, and welcome to our latest episode looking at different areas of law within the England and Wales criminal litigation system. So just a reminder, we're just touching upon some important legal issues, and today we're looking at legal privilege. And this is just a basic overview for those who are studying the law, and it's correct as per the Blackstone Syllabus 2025. But also it's just a general insight for the general public who may be interested in this area of law. Just a thank you to everyone who's subscribed thus far. If you are interested in the law, if you do find the videos helpful and insightful, please do like and subscribe. It does help grow the channel, so I do appreciate if you can do that. But let's dive in and have a look at legal privilege now. So we're talking about one of the most powerful protections in English law, and this is legal professional privilege, often shortened to LPP. This is the rule that lets clients speak freely to their lawyers. It protects confidentiality, honesty, and ultimately the right to a fair trial. Under privilege, a client can tell their lawyer the full story, the good, the bad, and everything in between, without fear that those conversations will later be disclosed. And crucially, privilege belongs to the client, not the lawyer. That means even if a lawyer wanted to, they cannot reveal privileged information unless the client authorizes it. This protection allows lawyers to give accurate advice because the client feels safe being completely open. Without privilege, the justice system simply wouldn't work. So in England and Wales, there are two main types of privilege, and each serves a distinct purpose. The first is legal advice privilege, and this covers communications between a lawyer and their client for the purposes of giving or receiving legal advice, even if the advice is bad or the client doesn't follow it. If it's genuine legal advice, it's protected. The second is litigation privilege, and this is much wider. It covers communications between the lawyer, the client, and third parties, but only when litigation is either ongoing, pending, or reasonably anticipated. And the dominant purpose has to be preparing for that litigation. So, for example, if your solicitor obtains some expert reports, witness notes, or evidence bundles, specifically for an upcoming trial, all of that is protected. Together, these two branches of privilege ensure that clients can seek advice and prepare their case properly without giving the other side a free preview. So privilege doesn't apply to everything a lawyer touches. There's an important filter the courts use, and it's the dominant purpose test. So this test asks, was the main purpose of this communication to obtain legal advice or to prepare for litigation? If the answer is yes, then privilege applies. If the communication is routine, administrative, or unrelated to advice, it won't necessarily be covered. And a key point here is that privilege does not depend on whether the advice was good or whether the client followed it. It also doesn't disappear when the case ends. Privilege can last indefinitely. And in criminal law especially, that's a crucial safeguard. So for the bar, of course, exams in particular, always ask yourself, was the dominant purpose legal advice or litigation prep? And that will be your roadmap. But when does it not apply? So now privilege is strong, but it's not absolute. There's a major carve-out called the crime-fraud exception. And privilege does not protect communications that are used to commit, further, or cover up a crime or fraud. So if a client asks, how do I destroy evidence? Or let's just say they ask, how do I avoid getting caught? Or how do I commit this criminal offence? That is not privileged. And lawyers exist to advise on lawful conduct, not help facilitate any wrongdoing. So if a communication is generally for legal advice, it's protected. If it's to help someone deceive or break the law, privilege is instantly lost. So for the general public, this is where many misconceptions begin. Privilege is not a loophole to hide crime. It is a shield for legitimate legal advice. What about a waiver then? So privilege belongs to the client, which means only the client can waive it. Waiver can be express, so the client tells their lawyer they want something disclosed, or it could be implied. For example, if the client relies on legal advice in court, if they say, I did this because my solicitor advised me, they may have opened up the door to the contents of that advice. There's also the idea of collateral waiver. So if a client discloses part of a privileged document, the court may require the rest to be disclosed for fairness and context. So the strategic message, once privilege is waived, it can't easily be put back in the box. Lawyers must make sure clients understand the consequences of waiving their confidentiality rights before they decide to do so. So to finish, let's step back for a moment. It's just a brief overview, but why does privilege matter? Because it gives clients the confidence to tell their lawyer the full truth. And without the truth, a lawyer's advice can't be accurate or effective, so it does go both ways. It also protects the right to a fair trial. It ensures justice is based on evidence, preparation, and proper legal analysis, not fear, secrecy, or half-truths. And most importantly, privilege is not a tool for criminals. It's a constitutional safeguard that protects everyone, businesses, families, victims, and defendants alike. So hopefully you all found that insightful or useful. It was just a very, very brief overview, so if you are studying the course, then please do refer to your textbooks for a more detailed insight. But otherwise, I thank you for watching. Hope you did find that helpful. And I'll see you on the next video. Take care for now.